Professor of Talmudic and Rabbinic Literature in the Department of Near and Middle Eastern Civilizations at the University of Toronto. She received her PhD in Talmudic and Rabbinic Literature from the Hebrew University of Jerusalem. She's published on Shmuel ben Hofnigan, and she is currently working on a commentary to Babylonian Talmud Tractate Genizah from a feminist point of view. Thank you, Tirzah.
For claims that Jewish jurists in medieval Muslim countries adopted al-Jaber's theory of tranquility of the soul in jurisprudence. Al-Jaber seems to lay out the following criteria or definition for this concept. When a person has tranquility of the soul in reference to newly acquired knowledge, and the knowledge conforms to previous knowledge, it yields the certainty that the inquiries generated truth. Therefore, there's no need for further inquiries. The endless questions are not necessary. Tranquility of the soul is by intuition, not perception. Like understanding the ugliness of injustice or the virtue of justice. And it's obligatory to rely on it, and it applies to all types of knowledge. The correctness of any sort of knowledge is if it can be characterized in terms of tranquility of the soul. Tzvi's first example from an anonymous Judeo-Arabic composition concerning monetary documents by a non-Jewish court with non-Jewish signatories, which are valid, actually uses the same phrase of tranquility of the soul, or that the souls achieve tranquility, so that when the souls become tranquil due to the knowledge, they rule on the basis of tranquility rather than on the basis of the testimony. So we accept that ruling simply because we are tranquil in our souls about it, but not on the basis of the testimony of the non-Jewish signatories. It also suggests that if it became clear that a witness were lying and the truth became manifest, the judge's souls would become tranquil, and they would rule according to that position when the truth became manifest. This definitely seems to adhere to the concept of tranquility of the soul, although there's no direction given as to how the truth becomes manifest. What happens if the truth doesn't become manifest and the judges have some kind of doubt? We would assume that through the process of Chakira and Drisha that things would become true, but what happens to the judges' souls if the truth does not become manifest? So can they rule or not? I mean, this first example from this Judeo-Arabic composition suggests that it's going to work out. Truth will become manifest, but that doesn't necessarily reflect reality. So, Rav Sadia Gaon's law of testimony, truth is that which those minds that are free of faults grasp, and souls who follow it attest. He questions how judicial sentence can be considered true because there may be an inability on the part of the litigants to explain or respond to claims, even though there seems to be knowledge in their souls. So this seems to be an issue.
5.
Yes, these are the parts that Tzvi didn't get to in his presentation. So here it seems to be a problem of articulation. The parties involved and the witnesses cannot articulate what they know in their souls. So then, the claim that God did not obligate the judges to believe any witness's testimony to be true, but merely to rule in accordance with two witnesses seems problematic. So, for instance, if I were a judge and had no faith in the testimony of the witnesses, it wouldn't matter. It would not matter. Why? Because according to Rav Sadia, I would have to rely only on the witness's testimony, only on their testimony. So it doesn't, so I'm not tranquil in my soul, but if I rule on their testimony, then what does that have to do with truth? Either the question of tranquility of the soul is either that's brought into question, or truth is brought into question. At the end it says, what does it mean that God would not order the establishment of a verdict upon their saying unless he promised a reward to the accused? God is going to step in and fix things, even if if the judges are believing testimony that is very problematic. But we should do it that way anyway, because God will come in and fix things. Does this mean that the judges are totally bound to the witnesses' testimonies even though they have doubts? Does it involve Hakira and Risha? What if they can't get to the right answer? Will it all be okay because God will give a reward to the accused? So he's accused and he's found guilty, but God will give a reward to him, and so then it's fine. So the only idea of tranquility of the soul here would be that you believe in the court system and its mistakes, and that its mistakes through untrue judgments will be fixed by God. So that's, from the point of view of jurisprudence, it's a problematic idea. So it's something that Rav Sadia, I believe this is the place that you were referring to, that he did not hold that you had to have tranquility of the soul, you just have to go by the witnesses. So this, assuming that there will be some kind of divine intervention here is quite problematic. Now, Rav Shmuel ben Hophni's case focuses, this is a case of a woman, of a husband who has accepted the testimony of one witness who testifies to his wife's infidelity. And on the basis of his complete belief that his soul is totally tranquil in reference to this one witness who, legally speaking, would not be sufficient to disqualify this woman from her husband. That is, they could remain married because it's only one witness. But because the husband has the deep conviction that tranquility of soul, that this woman, that she committed, that the witness, the single witness, is so believable that he will never then, he will divorce her and never be able to remarry her, because it's not a divorce and a wife that could be taken back, but it's a divorce in which it's as if it's been proven almost that it was a case of adultery. So the husband has tranquility of the soul, but not the jurist. So the question is, does the judge then say, at some point in the future when the husband comes back and says, now I'm not so sure, will he let him take his wife back? Or is it the husband committing to never taking the wife back because he has tranquility of the soul in reference to the one witness, which normally would not disqualify the woman? Now, Maimonides presents even a more problematic description. When the judge suspects that there has been deceit, or his mind or opinion is not relying upon the testimony of the witnesses, even though he can't disqualify them, or that his mind leans in the direction of that the plaintiff is deceitful and has tampered with the witnesses in some manner, although they seem to be valid witnesses giving testimony according to the simplicity of the manner, matter, or that there are hidden things that they do not want to reveal in giving their testimony, the judge is prohibited from giving a judgment. Now this is the negative description of tranquility of the soul. Since Rambam does not have tranquility, since this is something that does not exhibit tranquility of the soul, the solution is that he shouldn't give a judgment in this case. Just simply should not give a judgment. So this case, what happens with this case? Do you come up with a judge whose mind is totally at ease with the issue? And therefore, how does, if tranquility of the soul is something that is, we can intuit, how come Judge A has none and Judge B has enough that he can give a judgment on the matter? So it's it's the negative example of tranquility of the soul. And perhaps Al-Jabbar's description is optimistic, that new knowledge will come and be in conformity to previous knowledge and therefore lead to certainty, truth, and tranquility. For Maimonides, the judge simply has to step out of the case. What does that say about the judicial system in reference to tranquility of the soul? Perhaps a better example, a more positive example from Rambam would be Hilchot Sanhedrin Perkal Dalet Halacha Aleph, where it seems to be that the judge's intuition in the matter is much more positive. Yesh l'dayan l'dun b'dinei mamonot al pi hadvarim sheda'ato notah lahen shehen emet v'hadavar chazak b'libo shehukem. Or v'samcha da'ato shel hadayan al divrei, on these things that the judge must make his judgment in monetary matters according to that which his mind leans towards, that these things are true, and that the issue is strong in his heart. So his personal conviction. Okay. But this seems to be a very strong example of the personal intuition of the judge in the matter, in a case that comes before him. But unfortunately, in Halacha Bet it says, Kol elu hadvarim hein ikar hadin aval meisharabu batei dinin she'enam hagunim ve'afilu hayu hagunim b'maasehem enam hachamim karaui ubale bina hiskimu rov batei dinei Yisrael shelo yahu shavua ela b'raya brura and v'lo yadin hadayan b'smichat da'ato v'lo b'yediato. So that's the way it was earlier. It seems that the concept of tranquility of the soul was earlier, and then it got pushed aside because of dayanim who were either not sufficiently knowledgeable or not respectable in their hagunim, in their judgments. So it seems that in the past, but how far back can we take this concept of the tranquility of the soul of the judge? Can we take it back as far as Solomon and the judgment concerning which of the two prostitutes is the mother of the living child? Because he did an act in which the truth, what seemed to be the truth, it wasn't true. It says, she's the mother, don't hurt the child, she's the mother. And so that wasn't truth being stated, but it was Solomon's intuition that made him choose, identify the correct mother of the child. And then in Mishnah, we have this situation in Mishnah Bechorot 4:4, where Rabbi Tarfon declares a cow that has undergone a hysterectomy trefa. And he is so convinced of the validity of his judgment that he feeds the cow to the dogs. But then when the case comes before the sages, they say, no, it would have been kosher. And this possibly on the basis of the testimony of Todos, the physician. So what seemed to be a judgment that is based on the conviction of the judge on Rabbi Tarfon's original judgment got thrown out, and this got thrown out because he would, it turned out that he was simply wrong on the basis of another Mishnah and Todos's testimony. But then Rabbi Tarfon worried about his duty to compensate the owner of his fault for his faulty judgment. What would, he would pay him his donkey for that. But Rabbi Akiva relieved his mind and made his soul become tranquil, maybe, by informing him that as an expert of the court, he is exempt from paying in the event of an erroneous judgment. Rabbi Tarfon's original tranquility, or faith in his judgment, had nothing to do with truth. Rabbi Akiva's restoration of Rabbi Tarfon's tranquility also had nothing to do with truth. It simply stated the protective legislation enacted by the sages to protect the experts of the court for paying for their errors. So, my question is, sometimes what seems to be true knowledge, for instance, Rabbi Tarfon's position, actually turns out to be false, though he was tranquil about it. And so does tranquility of the soul of the jurist, is it something that's earlier and perhaps only took the formulation or achieved that specific expression because it was an expression that was in among the Muslim jurists? So was it a much earlier concept that came out, that was expressed the way Muslim jurists did, or was it indeed a situation where not everybody believed in the tranquility of the soul and only some people did it, so the anonymous author of the Judeo-Arabic composition took it? And I'm wondering whether, perhaps in further Genizah studies, whether we'll ever be able to identify that person, because that was certainly a case using that same terminology. But I'm just wondering whether the concept of that the judge has to be more tranquil, as it was in Rambam's first thing, was an earlier concept that just received that formulation. Thank you.